Yes. Good evening, everybody. I, Dr. Meenakshi Kalra, welcome you all on behalf of the Supreme Court Advocate on Record Association to this lecture series. Today, we've all gathered here for one of the important exam of leading cases in the upcoming AOR examination, wherein our esteemed speaker will enlighten us on reservation and promotion, freedom of speech and expression, damages in contract, arbitration, and appointment of arbitrator. We have the honor to have with us today Senior Advocate Shadan Farasat, sir. We welcome you, sir, and we're thankful to you for taking out time and discussing the important cases of Jarnail Singh versus Lashmi Narayan Gupta, Shreya Singhal versus Union of India, Kailash Nath, Cox and Kings versus SAP India Private Limited, and SPB and Company versus Patel Engineering Limited. We're showcasing live on YouTube, and if anybody has any questions, the same will be put in the chat box, and the same will be taken up in the end by sir. Now I would start the session by introducing sir. It's my pleasure to introduce Senior Advocate Shadan Farasat, sir, a distinguished lawyer who has been designated by the Supreme Court of India at just 40 years old. Sir has achieved this prestigious honor through his hard work and dedication to the legal profession. A gold medalist from the National Law School of India University, Bangalore, Sir further enhanced his credentials with an LLM from an esteemed Harvard Law School. With nearly 2 decades of experience in the field, he has developed a broad practice that encompasses commercial law, constitutional law, civil law, criminal law, among others. Prior to his designation as a senior advocate, Sir served as an advocate on record, demonstrating his expertise and commitment to the legal community. I'm confident that Sir's insights and perspectives will be invaluable to our discussion today. Please join me in welcoming Senior Advocate Shadan Farasat, sir. Over to you, sir. Please start with your session.
Thank you, Meenakshi, and thanks to SCAORA for having me for this session. I recall that about 12 years back in 2012, I was taking the AOR exam, and we had 4 lectures. And now, as SCAORA tells me, there are about more than 20. And I think even in the leading cases, it's been broken up. So 5 or 6 cases to every senior counsel. And I think that's a great initiative because the more inputs you get from, people who have been there little few years earlier than you is always very helpful. So I wish I had this kind of, detailed support. But kudos to SCAORA for doing this, and I really congratulate them. With that, I'll straight away begin on the 6 points on the lecture. So there are basically 6 judgments there, as Meenakshi said, they're from different parts of the law. I'll just go chronologically. So in that sense, SBP and Company, which is a 2005 judgment, is the first one I will deal with. I'll take about 5 to 8 minutes per judgment, so maybe 35 to 40 minutes, and then there can be some questions as I understand. Now, SBP and Company is a very important judgment, a seminal judgment on the issue of arbitration law. And it was a 7-judge bench decision, 2005. And at that time, the real core of the matter which SBP addresses is that appointment of arbitrator under Section 11, as it then existed, is really a judicial function, or is it an administrative function? And at that time, in the Section 11, the power was either with the Chief Justice of High Court for domestic arbitrations, and international commercial arbitrations, the power was with Chief Justice of India by name. So it wasn't to with the Supreme Court or with the High Court. It was under the section, the power lay with the Chief Justice of India or the Chief Justices of the respective High Court. And the question was in the exercise of that power, when the Chief Justice appointed under Section 11, or Chief Justice or his designate appointed under Section 11, then is that power judicial or administrative? And through a 6-1 majority, the Supreme Court there said that, listen, this power really is judicial. Justice Thakkar, in a reasonably well-reasoned dissent, said, no, it's administrative. And the reason why this judgment was so consequential in terms of this judicial versus administrative nature of the power being exercised is this. And this will be, just going away from the judgment for a bit. In my experience at least, all cases have a core and they have a periphery or a penumbra. So really speaking, each of these 6 cases have a core, and I'll try and address the main core. And that's also always helped me as a lawyer as well. And even in the AOR exam, if you understand the core of the judgment, of course, the ancillary points are also essential. They can be important ratios there. But really speaking, the core is something one must master in each of these judgments. So the core in SBP, according to me, is really this, that because it's judicial power, it can't be further challenged in a writ proceeding, in a 226. That really was what seemed to be troubling the court. And if it was administrative power, if it was the exercise of administrative power, then even the Chief Justice of India's appointment of an arbitrator in an international commercial arbitrator would have been subjected to a writ 226 challenge in a high court, because if it's an exercise of administrative power. And that's why I think the majority leaned in favor of it being a judicial power. And therefore, if it was a high court which was appointing it as a designate of the Chief Justice, then the only remedy would be a 136 SLP under the Constitution. And that is the appeal. Because from a judicial decision, what you have is appeals, revisions, etc. You can't have writs. You can have writs from a quasi-judicial order, but not from a judicial order, pure and simple. So that's the reason they leaned in. Of course, they have given various reasons as to why it was judicial power. And some of the important ones are that before a Chief Justice or his designate has to appoint an arbitrator, he or she has to ensure that he or she has the jurisdiction to appoint in terms of cause of action or other issues. He or she has to ensure that there's an arbitration agreement which exists, which has been signed by the parties against whom arbitration is being claimed, etc. So there are determinations of a certain nature which are in the nature of judicial determinations and not pure and simple administrative decisions which have to be made. Justice Thakkar's dissent really said it's administrative just because you are required to make certain decisions prima facie, and that was his view. Doesn't mean that those are judicial determinations. His view also was that, listen, if you a lot of administrative powers are powers exercised within the parameters fixed by a statute. So this is one of those powers which under 11.6 you have certain parameters which are fixed and you make that appointment under that. And that's why he leaned in favor of calling it an administrative power. He made a differentiation between how they can't, just because the nature of the power cannot be determined by what remedy against remedy which will be exercised against that power. So the fact that you can have a 226 remedy will not determine whether the nature of the power is judicial or administrative. You have to determine that individually. But SBP essentially is crucial on the point of the nature of exercise of power by the Chief Justice. Subsequently, of course, there were amendments in 2015 and again in 2019, and the power therefore really was moved away from the Chief Justice to really the court itself. And that was also a response to this whole dispute, which arose in the nature of judicial versus administrative. Because if the power lay with the Chief Justice, not really the power with the court. So subsequent, there were amendments made, which in effect, Parliament sort of moved in and clarified some of those aspects, which really lay at the center of the dispute in SBP and Co. Today, it is therefore not that important a judgment in today's arbitration practice in that sense. But nevertheless, a lot of first principles are there because it's a detailed judgment, which you'll also find in this decision. And yes. The other point, which is ancillary point, really not the core point, but ancillary point, which comes up in SBP is that it also said that the arbitrator itself is, if there is a determination which has been made in a section 11 by Chief Justice or designate or in a section 8 application by a court, then the arbitrator herself or himself is bound by those determinations. She or he cannot override those determinations. So that is another point which was, held, which was decided in SBP, and that is also of continuing relevance. Now, that was the first judgment, 2005. Then that brings me to the second judgment, which is Shreya Singhal. And Shreya Singhal, of course, is a very popular judgment in the sense it's very often quoted. And I feel that it's possibly the most consequential 19(1)A judgment we have ever had on free speech in India. I mean, there have been a lot of others as well, but I think just in terms of the doctrine of 19(1)A, of what free speech really means, I think is encapsulated beautifully in this judgment. It was only a two-judge decision, Justice Chalmeshwar and Justice Nariman, and the Justice Nariman wrote the judgment. And again, why this judgment? The core of this judgment is this, that if you have to restrict speech, you have to restrict it only under one of the 8 heads which are identified in Article 19, subclause 2. You can't do it beyond that. There is no 9th head, there is no 10th head, there is no 11th head, right? There are no imaginary heads. And I think it put it very clearly and beautifully for the first time in our sort of 19.1 jurisprudence. That was always there in the background. Of course, 19.2 restrictions can be under one of the 8 heads which are mentioned there. But I think it brought that point right at the center of that decision. And I think based on that, then it examined Section 66A of the IT Act. And it said, listen, the IT Act, Section 66A is very broad. The words which are used there can cover both speeches which are merely leading to discussion and advocating a point of view, which is not connected to any of the 8 heads. And even those will be brought in within the restriction. And therefore, it goes beyond what 19.2 permits you to restrict. The other important aspect of this judgment is really this. It makes a very clear distinction between discussion, advocacy, and incitement. And I think the important point is that under our jurisprudence of free speech, both discussion and even advocacy is fully protected speech. It's protected under the Article 19.1a. But it's only when it reaches the stage of incitement, and incitement relating to one of those 8 heads again. You can't have incitement relating to some 9th or 10th head beyond that. So incitement relating to one of those 8 heads, then that's when the 19.2 restriction can come in. And what the court said there, that listen, 66A is so broadly worded that a lot of speech which is dealing with advocacy and which is also dealing with just plain discussion will also be captured within that power of 66A, and the government can restrict it. And therefore, it clearly violates 19.1a and is not protected by 19.2. So that's the second big thing. And I think what is important there really is that, and it's very, very relevant for our times presently even, because a lot of these 19.1a cases keep on coming to Supreme Court also. Even currently in the last 3 or 4 months, we have seen some 3 or 4 very well reported ones which have come to the Supreme Court. And there, I think, quite importantly, the Supreme Court notes in Shreya Singhal, and this is something I think this is also one of the sort of crucial points, that even speech which is grossly offensive, and the words used are grossly, the phrase used is grossly offensive, is actually protected until it leads to incitement related to one of the 8 heads. Now, you can imagine some of those cases which have come to the Supreme Court in the last 3 or 4 months, where speech by, say, YouTubers, etc., public at large may find it offensive, even grossly offensive, but that is still protected speech. So I think if you were to follow the Shreya Singhal sort of principle, which puts the 19.1a law very clearly and succinctly, then maybe some of the observations which we have seen coming from the Supreme Court in those decisions were possibly not warranted, because really speaking, those were exercise of protected speech. And another thing which is very important, which Shreya Singhal really dwells upon, is that the right to free speech is not for speech which you like. Because of course, speech which everybody likes is anyways never going to be shut down, right? A speech which 70% of the population likes is not the kind of speech which is going to be shut down or restricted. Government is going to restrict speech which a lot of people may not like. Government or an agency of the government is going to likely to restrict speech which a lot of people may not like. But the whole idea of free speech is that, and it draws from the American jurisprudence here and says that, listen, it's a marketplace of ideas. Some ideas which are really today's mainstream ideas become outliers, 25 years from now, and today's outlier ideas become mainstream. So it is only when in this marketplace of ideas we have continuous exchange between different ideas, which may be today outlier, really a shrink, outside the mainstream, that you can have an evolving society. And it is not for the government to choose which idea to propagate, but it is really for, in that marketplace of ideas, for the people to choose, living in the times and space that they live in. And that also it really brings in. What it also says is that although the American law on free speech is different in the sense that there is no 19.2, but it's not as if it's completely different. It also says that in Indian jurisprudence also, you can draw from American law of free speech And it's not as if they are completely divorced from each other, because some of the earlier judgments sort of indicated that, oh, it's because there is no obvious restriction there, it's an unlimited power there. That's not correct. I mean, there also the US Supreme Court has laid down tests to restrict. No power is, any constitution is ever completely unlimited. So in that sense, the right to free speech there is not a completely unrestricted right either. And the Shreya Singhal court really makes that distinction and says that to that extent we can draw from the US court jurisprudence. So I think those are the 2 or 3 broad hallmarks of the Shreya Singhal judgment. Now, Kailashnath judgment is the third one, because that's also 2015 one. Now, Kailashnath is an interesting judgment. Just, I will first take you through some of the facts because that's relevant. This was a case where earnest money of deposited by one of the parties to a 1982 contract was effectively forfeited. And this was not on account of any breach by the party, because extensions were continuously given by the other side. Was DDA here. This related to a property in Bikaji Kama Place, which some of you may know is in southwest Delhi. That Bikaji Kama Place had come up in early 1980s in Delhi, and that's it related to one of the plots there in 1982, commercial plots there. And the question really was that they paid earnest money, and then for the remainder payment, DDA kept on extending a period. And eventually, although the other side was agreeable to pay, they changed the stance, because the government of India I'm just sort of paraphrasing and shortening it a bit, because the government of India had a slightly different view on things, and then it re-tendered it. So the original tender was for about 3 crores. This bid, which was successful bid, for which the person paid about 75 lakhs odd. And then when in 1990s they re-tendered it, they got nearly 11.5 crores approximately. Now, but despite that, they forfeited the 75 lakhs of the original tenderer, of the original successful bidder. And that is what the challenge was, to the forfeiture of that earnest money. And in that context, the question which arose really were twofold. First question which arose is that, can you forfeit earnest money despite there being allegedly no breach to the contract? Because here the communication showed between the parties, between DDA and this private entity, that this private entity was always willing, although the initial timelines had been crossed and there were extensions given, but the private party was always willing. And therefore, there was never an instance where they had breached the contract. So if there was no breach, where was the occasion to really forfeit the earnest money? That was question one. And second question was that, since on retendering, DDA could get about 11 odd crores, which is much higher than 3 crores. Therefore, really, they didn't suffer any loss. So where was the question of forfeiture there also? And these two questions arose in the context of Section 74 of the Contract Act. Now, as some of you may know, Section 74 of the Indian Contract Act is effectively sandwiched between 73, 75, which are both dealing with compensation/damages for breach of contract. And the question really in this context of 74 was whether you could have a liquidated sum of damage. Now, in this case, there was a clause which said that if earnest money is whatever, in case of a breach, it can be forfeited. There was the power of forfeiture, which was there with DD under the contract, and they exercised that power. So the first question was that, in the absence of breach, can you exercise that power? Number one. And second, which is purely a question under the context of Section 74, was whether you can effectively have a power like this, so that even when you can prove the loss, or where it prima facie shows that there was no loss, in this case 11 crores you sold it, so it's obvious that there was no loss, then can you still be invoking this LD kind of a clause, liquidated damages clause, even though when there is no loss, because you've actually made a profit? Now, on both those questions, what happened was a single judge decided in favor of the private entity, and they said, no, you must return this forfeited amount. The division bench of the Delhi High Court reversed that, and the division and then that was further challenged in the SLP. Now, the Supreme Court really, what it did, this is again just an Nariman's judgment. What it did was it sort of went into what was the meaning of Section 74 and why it was introduced and why it existed, and examined the judgments from Fateh Chand, then Maula Baksh, and then ONGC. And then finally came to the conclusion. Two important conclusions were there. First was that something like earnest money is fully covered under Section 74. There was observation in Maula Baksh which created some confusion. So that observation, they said, was obiter because that issue didn't arise in Maula Baksh, and therefore they put it on the side. And they said, therefore, earnest money is also fully covered under Section 74. Then they examined, and this is the core of the reasoning of this decision. Then they really examined the meaning of Section 74. And what they said is that in Section 74, firstly, if you have determined an amount which is a genuine pre-estimate of damages and not in the nature of penalty, then that amount has to be paid. Second, if you can prove that amount, then you are obligated. If the nature of the contract is such that you can prove that amount, then you must prove that amount. It is not an exemption for you to prove that loss even when you can. So for instance, I'll give you an example. Say there is a price differential which happens because between in a contract for sale, like X cotton. Let's say let's take example of cotton. You were supposed to buy it on X date, something moved to Y date, and then there's a delay in purchase. By then the price changes. Now, in case like this, you can determine the market price on the contractually stipulated date. You can determine the market price on the subsequent date, and therefore you can prove the loss. Now, in a contract like this, even if you have a LD clause for delay, that by itself will not be sufficient to ensure that you don't have to prove the loss. We see it in arbitrations all the time. All lawyers, I mean, some of you may also have done arbitrations in which you have to show, despite a LD clause, the actual loss which has occurred in that contract. Now, because the nature of the contract is such that you can prove it. Now, of course, there can be some construction contracts or engineering contracts where it's typically very difficult, especially in complex construction contracts, to prove losses. And their LD clause comes in full play in the sense that you can't prove the loss and therefore you're not required to prove the loss. But the important thing here is that in contracts, 74 is not an exemption. In cases where you can prove the loss, it operates as an exemption only when the nature of the contract is such that factually you can't prove the loss. And that's one important point. Second was that, of course, if it's in the nature of penalty, that if the amount which is stipulated in the contract is in the nature of penalty and not just as a genuine pre-estimate of damages, then it will have to be determined if that penalty is reasonable by the arbitral tribunal or the court, as the case may be. And only to the extent that penalty is considered reasonable will it be allowed. And that penalty, and this also Kailashnath specifically says, that penalty is the ceiling amount. So a court cannot grant higher than that penalty amount. So if, say, the penalty is 5% of the contract amount or 10%, that is really the ceiling. But the arbitrator of the court will still have to see if 10% is too much. So 10% is the maximum they can grant. They can't grant 11%, number one. And number two, even to grant 10%, they'll have to see if in the facts that's reasonable. If in the facts they feel 10% is too high, then they can only grant 5 or 6 or 7%, whatever they feel is reasonable. So those are the two things which really arise in Kailashnath. I mean, the way I read Kailashnath is really for the 2 or 3 propositions. One is that earnest money and its forfeiture is covered by Section 74 and the logic thereof. Number two, that there is a difference between genuine pre-estimate of damages and penalty. In the context of genuine pre-estimate, you have to, in both those cases, actually, if you can prove the losses, then you must prove the losses. Only in cases where you can't prove the losses, the obligation of proof is done away with. And thirdly, that actually those are the primary 2 points which arise in Kailashnath. Now then we come to, just let me see if I missed out anything in Kailashnath. No, I think that's broadly covered. Now we come to the next judgment, which is a 2017 judgment, Shaira Banu. Now, Shaira Banu was a judgment. In fact, I was there in that matter, so I have a good understanding of what we argued and how it went. it was a matter related to instantaneous triple talaq practice. So basically, what the practice which was in there in South Asia amongst Islamic and Muslim groups was this, that if you say in one go, a husband could say in one go talaq, talaq, talaq 3 times, and at the pronunciation of the third time, the wife would effectively stand divorced. Now, that really was something that was a practice which was not permitted as per the Islamic text, Quranic text. And even the other sort of documents, hadith, etc., which is relied upon to interpret Muslim personal law. But it was something, a subsequent innovation which arose at a later point in time in the history of Islamic law. And there the question really was, there was a challenge to this practice. I was also for one of the parties which had challenged this practice. And there were two kinds of challenges before the court. One was a pure and simple constitutional challenge saying this is arbitrary, set it aside. So that was one bunch of petitioners. The second bunch of petitioners were really saying that, listen, this practice by itself is not a practice which is permitted by Islam. It's to that extent an un-Islamic practice, because it does not find its place in Quran. It does not find its place in the formational text of Islam, as it were. And therefore, it's a subsequent innovation in a very specific context. And that's why it's called in the language talaq-e-biddat, which means it is an innovative form of talaq. And therefore, this instantaneous triple talaq should not be permitted. Now, and it should not be permitted because under the 1937 Sharia Application Act, it is only through the Sharia Application Act that Muslim personal law applies to Indian Muslims. And that basically only Muslim personal law, as recognized in the Sharia Application Act, is what is applicable to Indian Muslims. And since this is not part of the Quranic text or original practice, this is not part of Islamic law, and therefore there is no question of it applying to Indian Muslims at all. You declare that it is a un-Quranic practice, it is an un-Islamic practice, and you declare it as void practice. You don't therefore need to test it constitutionally. It's only once you come to the conclusion that, listen, this is actually part of the Sharia as it applies to Indian Muslims, that the need or the question arises to test it against Article 14 or other constitutional fundamental right article. Now, these were the two lines of argument. So one line was saying arbitrary, declare it unconstitutional. One line of argument was saying, listen, just declare it to be un-Islamic and therefore not part of the personal law which applies to Indian Muslims. And in that case, if you were to find that to be correct, then you don't even need to test it against the constitutional safeguards, as it were. And 3 sets of judgments were given. I think it's very important because in this judgment, a lot of mix-up very often happens. 3 sets of judgments were given. So Justice Nariman, speaking for himself, and Justice Lalit said that, listen, this practice is arbitrary and therefore it cannot be a valid practice. It's unconstitutional in that sense. So that was one line. Before this, of course, he basically undid the McDowell line of judgment, which basically said that, insofar as arbitrariness or manifest arbitrariness is concerned, that cannot test a proper legislation of a parliament. It can only test, rules or delegated legislation. Arbitrariness cannot be a basis for testing a law passed by parliament. That was the McDowell line of judgment. So he undid that and he said that's incorrect. And then he says that, listen, this practice is arbitrary. So there's a point of law which he makes, and there's a point of, in the context of the practice, he finds the application of that law saying, okay, this is a manifestly arbitrary practice, out you go. Justice Kurian Joseph, speaking only for himself, really was the most crucial fence sitter in this matter, and it's important you understand it. What he does is, he agrees with the side which says that this is an un-Islamic practice. So he says, listen, this practice is un-Islamic, therefore it's not part of Sharia law at all, and because it's not part of the Quran, etc. So where is the question of it applying to Indian Muslim? Therefore, it is illegal. And at the same time, he agrees with Justice Nariman's analysis of McDowell being wrong judgment. But he doesn't agree with his finding that this practice is arbitrary, because he comes to the conclusion that under Islamic law, this is illegal. and therefore it doesn't apply. Therefore, the equation to test this against the constitutional precept doesn't arise. So he agrees with really the second line of judgments, the second line of arguments which were made by the petitioners. But he also agrees with Justice Nariman on the point of his analysis of McDowell v. Brown. So when we quote Shaira Bano on the point that it is on the point of manifest arbitrariness, it says now that legislation can be tested. You have Justice Nariman supported by Justice Kurian Joseph's reasoning on that legal point, which forms the ratio. But on the application of that, there's something very crucial. So Justice Nariman says it's unconstitutional because it's arbitrary. And Justice Joseph says that, listen, this is this is un-Islamic and therefore illegal. So as a result, the instantaneous triple talaq is found to be illegal practice. It is not found to be unconstitutional practice, because Justice Joseph did not agree with the two. You need in a 5-judge judgment, you need 3 judges to agree, right, to have a majority. So there were 3 judges did not agree that it was unconstitutional practice. They agreed on the result that the practice is illegal. But 2 judges, Justice Nariman and Lalit, agreed for the reason they found it to be arbitrary as per the constitution. And Justice Kurian Joseph said it is illegal as per Islamic law and therefore it has to go. So for different reasons, they agreed on the result, but not on the same. So the outcome is 3:2, because the 2 other judges, Justice Keher and I think it was Justice Nazir, said, no, this is a valid practice, etc. So this is important to understand on that the practice has been declared illegal by the Supreme Court, not unconstitutional. Although on the aspect of manifest arbitrariness and the law being tested on that anvil is something which 2 + 1, 3 judges agreed upon. So that's Shaira Bano for you. Then we come to Jarnail Singh. It's a 2018 judgment. And this is the Constitution Bench judgment on the aspect of reservations. And here the question really was that the correctness of Nagaraj on 2 points. Nagaraj was a 2005-6 judgment which basically was which upheld the validity of certain constitutional amendments in Article 16, if I'm not wrong, 15 or 16, 4A. Just give me half a second. So, yes. Yes, it was in 16, correct. So, that was in promotions, reservations can be there, and there was another amendment in 4B. Now, the 2 points of Nagaraj which were questioned here, first was that when you are including a scheduled caste or scheduled tribe, do you have to test the backwardness of that group also? So somebody is, as you probably know, you become a community becomes a scheduled caste community if it is as per the presidential list of 341 and for scheduled tribes 342 is in the list issued by the president. The original list was issued around 1950 and thereafter only parliament can modulate it. Even the president, that is the executive, can't modulate or change it, cannot take out a caste, cannot put in a caste. So those are the presidential lists for scheduled caste and scheduled tribe. So what Nagaraj had said that, listen, even for scheduled castes, you have to determine their backwardness before giving them reservation. Now that question was the first one which was being reconsidered by this bench. The second question which was being reconsidered was that Nagaraj has also indicated that, listen, there is creamy layer as a concept could be there in scheduled caste as well. And that point was also being argued that, listen, there can't be any creamy layer in the context of scheduled caste. Creamy layer is only a OBC concept. So that was what was argued, and therefore Nagaraj is wrong on both those points. Now, this was a 5-judge bench. It was testing another earlier 5-judge bench. So if it had disagreed with a certain 5-judge bench, it had to then refer it to a 7-judge bench for it to be set aside. What happens is that on the first question, that is whether you have to determine the backwardness of the scheduled caste also before giving them affirmative action, it says that, listen, insofar as that question is concerned, the finding in Nagaraj is directly contrary to the majority in Indra Sani. And since it is directly contrary to majority in Indra Sani, it has to go, and we don't even really need to refer it to 7 for that. So they say that part of the finding is incorrect. being contrary to Indrasani, and therefore that's not good law. Insofar as creamy layer is concerned, they say that, listen, creamy layer as a concept is really a concept of equality. It is not just a concept of identification, because if you are going to treat unequals as equals, then, Article 14 and the principles really collapse. So it says, in that sense, creamy layer in scheduled castes and scheduled tribes should also be there. There's nothing in the constitution which really seems to prevent it, is what they said. And in that context, they say that you can and you must, in fact, it goes so far as to say that you must have creamy layer in scheduled caste as well, scheduled tribes. I personally disagree with the second part of the reasoning of this judgment. That's my take on this judgment. Creamy layer as a concept, but before I come to that, the reasoning they said is that a person, once he belongs to scheduled caste, is part of that group. Creamy layer is a mechanism which individually plucks out people. So if you have from that group, you continue to be scheduled caste, you continue to be, say, a Dalit caste, whatever your caste is. It's not as if your caste ceases to exist. But what the judges in journal say, but because you have 8 lakhs and above income, or you have a government job, you're a second generation, whatever the test for creamy layer may be, then you are as an individual plucked out, and you're not given the benefit of reservation. Although you continue to be part of the scheduled caste, scheduled tribe, therefore there is no interference, or there is no tinkering, is the word used, with the list under Article 341, 342, because you continue to be part of that list, but at the same time, you will not get benefit of the reservation, as you are part of the creamy layer at an individual level. So at a group, you continue to be part of the group, but given your individual circumstance, your socioeconomic status is above, and therefore you're pulled out. So that's the justification which the court gives. And on the face of it, it seems like a very, very attractive justification, right? Theoretically, it seems like a very, very attractive justification. My personal view on this, however, is that I think the court got it slightly wrong here. And the reason it got it wrong is that it missed the socioeconomic circumstance on the ground in even today. Now, just look around and see how many scheduled caste and scheduled tribe people are there in post or jobs, or even in the Supreme Court bar or anywhere else. You will find very few numbers of scheduled caste, scheduled tribe individuals who are there. Therefore, where is the question of any creamy layer is basically a concept which, as the cream in the milk, once you heat the milk, is on the top. It's the top layer, right? It's the thin layer on the top, and then the rest of the milk is all down. So the idea is that the very top layer, which is a thin layer, should be excluded because of the beneficiary. But in the case of scheduled caste, scheduled tribe, even today, the social reality is this, that in most positions, government jobs, even high-level educational institutions, there are only 1 or 2 or 3. Very few in terms of percentage, very few, right? Despite reservations. So if you were to exclude them, then where is the milk and where is the cream? In the context of scheduled caste and scheduled tribe, the milk is the cream and the cream is the milk. There is no separate cream and milk, right? OBCs, that may be true, that really speaking, you have a creamy layer, you have a large chunk, you have a larger representation. But I think in scheduled caste, scheduled tribe, there's really no creamy layer in that sense. Because the number of individuals who are there are very few. So although theoretically this concept in Jarnail Singh is very appealing, I think it misses the ground level social reality in India today as well. Important thing to note is that Davinder Singh, which is the judgment, the state of Punjab versus Davinder Singh judgment, is a 7th judge which came out last year. Also, some judges there also, I think Justice Gawai and a couple of more judges have said that creamy layer have commented on creamy layer issue. Although that was a case of subcategorization within scheduled caste. So there's the main question, and I'm only saying it's become relevant because I'll tell you why in a minute. There the question was that once a scheduled caste group, you have a list of scheduled castes, can the state government then sub-classify them? Can they say that, okay, for 2 of these scheduled castes, we'll have preferential 25% quota within the quota? So it basically was a quota within the quota issue. And there was an earlier judgment of the Supreme Court called Chennaiya, which said you can't do because that amounts to tinkering with the presidential list, which only the parliament can do, no state government can do it. Supreme Court reverses that in this and says that you can do it, and to determine if 2 groups are different within the scheduled caste, somebody is more backward, somebody is less backward, then the test is you have to have data to show a more backward, less backward, that is a relative backwardness. And second is the access to governmental institutions, or the presence of that subgroup in governmental institutions and jobs. So why it's important is that although this judgment, that is Jarnail, says that insofar as Nagaraj is finding that for giving somebody reservation, giving scheduled caste reservation, you have to test backwardness is wrong. And that still stands. But now, in subsequent to Davinder Singh judgment, the backwardness of scheduled caste is although not relevant for giving them reservation per se, but the backwardness of scheduled caste becomes relevant for the purpose of giving them subquotas. So that's important to understand. So to that extent, the position really in journal stands changed by Davinder Singh, because the backwardness of scheduled caste has become relevant in a different context. That is not every scheduled caste is assumed to be backward. Yes, that position continues, as Jarnail said. But today, to determine whether somebody is more backward, one group is more backward or not, you have to test the backwardness before giving them reservation as a subquota. So that's what important of Devinder Singh. So that's Jarnail for you. Then we finally come. I think now I am on the last one, and that's Cox and Kings. Now, Cox and Kings really is also a very important judgment, because here the question was the group of companies doctrine. And in this group of companies doctrine, it arose in the context of arbitration. And the point is, as most of us know, that in an arbitration agreement, only the signatories are bound by it. That's the classical position of law. That's the privity of contract principle, correct? Now, that has been actually the Indian legal position right up till 2013, when a judgment called, a 3-judge decision called Chloro Controls came in. That was the first judgment which changed that position. And Chloro Controls basically said that if in a multi-party transaction where there are many corporations, subsidiaries, group companies involved, there is a concept of a single economic unit, or that although the agreement has been signed by only some of the parties, the entire project or the entire whatever is contracted for cannot really function without others also acting. Then we will apply the group of companies doctrine, and even non-signatories in that context, there were some subsidiaries, etc., who could also be made liable under the arbitration agreement and therefore be made a party to the arbitration process. Now, the Chloro Control, which was a 2013 decision, went on the concept of a single economic unit, or that when looked at it structurally, you really have, although there are various parts and various entities in terms of legally defined entities and companies, the transaction is being carried out by one whole unit, and each is part of the other in a way that one cannot function without the other. So it went on structural sort of notions. Now, Cox and Kings arose in the context that a 3-judge bench doubted the correctness of Chloro Controls and its application as a doctrine to India. And in that context, it went to 7 judges. And here, the majority really basically says this. It says that just like and this is the core of Cox and Kings, and it's important to understand this. Just like in a contract, you can have an express contract, that is, you have agreed by signing it, and you can have an implied contract. You can also have implied consent for the arbitration agreement. That is, you may not have signed the arbitration agreement, but the doctrine of consent through your conduct and otherwise can show that you were a veritable party, that is really a true party or a genuine, a real party to that contract as well, despite having not signed it. Now, the distinction between Chloro Controls and Cox and Kings is this. Chloro Controls goes on the structure of the company. It goes on whether it's a single economic unit, etc., etc. Whereas Cox and Kings says that, boss, it has to be based on consent. It may be implied consent. It may not be express consent through signing a document, but it has to be nevertheless based on consent. It can't be without consent. So Cox and Kings says that although this group of companies doctrine is what it is called. So single economic unit, really speaking, is only the first part of the test which a person has to meet when asserting that a non-signatory is a party. So you have to say that they were connected, etc. There's a group of, it applies only in the context of different group of companies. It doesn't apply in other contexts, right? So the single economic unit to that extent is relevant to show that they were connected, etc. group, but that's not sufficient. It's necessary, but it's not sufficient. To further, you have to show from the situation under which the contracts came into being that these other parties, which are not actual signatories, through their conduct, agreed to be part of the arbitration agreement. So really speaking, they applied the concept of implied contract under the Contract Act, read with the arbitration agreement, and said that if there is consent, even though implied, then in addition to a single economic unit, if there is consent, that's the second leg, then you will have a party which is not signatory also be made part of the arbitration agreement. So what has happened is that a lot of people generally say, and I think it's completely wrong, is that said, oh, the Cox and Kings has reaffirmed chloro controls the concept of group of companies doctrine. I think that's wrong for the reason that Cox and Kings has shifted the center of gravity of the doctrine from a single economic unit to a consent-based doctrine. So now in an arbitration, and I've done a few of those matters, both in court and in arbitration, what you really have to show is that from the document at the time of formation of the contract, there was implied consent. Who were the people who were this thing? Were the officers of the subsidiaries really actively taking part in the contract negotiation, for instance, or things like that, right? Where were the consents coming for? Although even only the subsidiary was a part, but were the consents only coming after the approval from the parent company? Things like that. So by conduct, if you can show there was consent, then only this doctrine will apply. Although single economic unit continues to be an important factor, it is only one of the two factors now. And therefore, the center of gravity has shifted from single economic unit to a consent-based doctrine. In particular, you will determine consent from evidence at the time of formation of the contract, and which is where most of the litigation today in this context happens. So I think with that, if I'm not wrong, I have covered all the judgments. Yes. So now we can, I think, go ahead with the questions.
Thank you, sir, for such an extempore and enlightening lecture. I'll just start taking the question. The first question has been asked by Abhimanyu Yadav. And he's asked that, sir, is the state of Punjab and others versus Devinder Singh and others a step forward to General Singh as it recognizes NCL in the Supreme Court?
Non-creamy layer. NCL means non-creamy layer.
Yes.
Okay. No, so my view, as I said, I mean, I have partly answered that question. My personal view is that I think creamy layer we are little ahead of our time in declaring creamy layer in scheduled caste. Maybe a time will come, but today, if you look at the ground reality, I think there is no cream and there is no milk. The milk is the cream is the milk. So if you reduce the cream, the milk is also gone, right? So my view, therefore, is that we are probably a little ahead of the time. I guess a time will come for introducing creamy layer in scheduled caste, but it's not today. That's my point. So I don't think it's a progressive measure in that sense. Possibly it should have come at a later stage. That's why, just if you noted, although the Supreme Court has declared it, not a single state government and not a single or the central government has initiated creamy layer in any of the scheduled caste, scheduled tribe reservations. Because the governments really on that context are more aware of the ground reality than I think the theoretical foundations on which Jarnell or others have introduced the concept of creamy layer.
Thank you, sir. The other question is again by Abhimanyu Yadav. He's asked that, does essential religious practices have relevance in Shaira Banu? And can you elaborate, taking into consideration other decisions of the court subsequently?
That's a very good question. See, essential religious practices was also argued by a bunch of people, and two judges, Justice Keher and Justice Nazir, in fact, went ahead and said that it's an essential religious practice, which I think is plainly wrong. Because a practice like instantaneous triple talaq, which is obviously a practice which cannot, forget a modern society, even in 7th century AD when Islam came, I mean, it is completely absent in the Quran. It's completely absent in subsequent practices. So it was not essential religious practice. It was an innovation brought in many 100 years after Islam came into being. So it was not essential religious practice. And I think that Justice Keher and Justice Nazir's judgment, my personal sense is a completely wrong judgment. It got the whole thing completely wrong. Secondly, I mean, how do you in 20 in the 21st century justify a practice like instantaneous triple talaq as an essential religious practice and uphold it? You can't. It's such a arbitrary practice in its own way. So I mean, the court really had two options, like I explained: either go the constitutional route and say it's arbitrary, or say that it's not part of Islamic law, both of which were legitimate options before the court. One judge chose one option, the other two chose the other option. And through majority, we came to that conclusion. Subsequent ERP decisions, see, I would say that ERP as a doctrine itself is problematic. I think we have to reconsider, because for judges to determine what is essential, what is not essential, and therefore grant protection is very problematic, because it is so relative. Religious practice itself is so relative across different religions that something may be more essential to a subsect, to another subsect it may be less essential. Then how do you go about determining essentiality from as judges? It's very difficult. So I think that doctrine itself should go. You should protect irrespective of whether it's essential or not, subject to other constitutional restrictions. That's my sense.
Thank you so much, sir. I would now request Member Executive Aditya Giri to please give the vote of thanks.
Thank you, Meenakshi. On behalf of entire SCAORA Executive Committee, I extend our heartfelt gratitude to Shadan sir for delivering an exceptionally insightful lecture on these 5 leading case laws for the AOR aspirants today. Sir, your comprehensive analysis of these landmark judgments and practical guidance on their application in the legal practice have provided our members with invaluable knowledge that will undoubtedly strengthen our preparation as aspiring AORs practitioners. And we deeply appreciate your expertise, time, and dedication to mentoring the next generation of advocates. Thank you once again, sir, for this enriching session and your continued support to SCAORA.
Thank you for having me.
Thank you.
Really had a very nice time. Thank you.
Thank you, sir.
Thank you, sir.